between 20 to 30 minutes.
Thank you. My topic of presentation is analyzing legal architecture to deal with terrorism and belligerency under India's constitutional structure. I have divided the whole presentation into following parts. It's about the India's internal security issues. And before we go ahead, I would like to give you a general information about India. It's located in Southeast Asia, having a population of 1.3 billion, full of diversities, such as we have 22 official languages, around 1600 dialects, and all the major religions of the world. So in this highly diversified population, it's a mounting challenge to maintain peace and security in the internal affairs. India having a federal structure which is having 29 states, 7 union territories, and a central government. Any country, whatever kind of internal issues it is facing, having some correlation with its past. India is not an exception to this basic rule. India's colonial legacy has created a havoc in its internal spheres. India got its independence in 1947, and the colonial rule for around 200 years practiced the divide and rule policy in India, and that policy became the major cause for its partition on the basis of religious identity. Not only this, when the colonial rulers left India, they left India with the two states beside two states. They left other separatist tendencies, and they given them option if they want to go with Pakistan or India, or if they don't want to go with them, they can declare themselves as a nation. So at that time of independence, India was in a situation where around 20 to 25 states or countries could have been emerged. But it was the Constituent Assembly of India which has provided a kind of constitution where all the parts came together and became India. So now coming to the belligerency, or in Indian context, I would like to use the word insurgency because it is very much prevalent in India's legal matters. So insurgency is a kind of activity where people or group of people want to overthrow the government system and to establish their own system by using the force or violent activities. Insurgency in India having three main categories. One is prevalent in northeastern India, that is having narrow ethnic nationalism. Second type of insurgency is prevalent in the east central India, and the third kind of insurgency prevalent in Jammu and Kashmir and Punjab, that is religious extremism and militancy. So in the map you can see here this is state of Jammu and Kashmir and Punjab, and this is northeastern part of India, these 7 states, and this is the east central part of India where the nationalism is affecting around 20 states of India's federal structure.
Could you define nationalism?
Yes.
Yeah, I'll come on that. In 2005, these are the parts affected by nationalism, and at present, this is the only area left under the influence of nationalism. The red one is severely affected area. So coming to the nationalism. First, let's begin with the narrow ethnic nationalism of Northeast India. In the early 1950s, there were many tribes in the northeastern part of India, and those tribes were motivated by the kind of space left by the colonial rulers. They were motivated to create their own nation, but their nationalism was limited to their own tribes only, and they were not even ready to accept existence of other tribes in that area. So they started attacking not only the government establishment but also the other fellow tribes. So this created a kind of chaos and unlawfulness in the northeastern part of India, and the state government of Northeast India requested to central government to help and to send some forces. So at that time, a very well known act which is known for its criticized a lot, that is Armed Forces Special Powers Act 1958, which came into existence to bring normalcy in the northeastern part of India. The second type of insurgency in India is Naxalism. In the state of, that is West Bengal, here, a small peasant uprising took place in a village. The village name was Nex Albari. And with that uprising, although that was suppressed by the police and paramilitary forces, but later on it keep on spreading and took its inspiration from the Chinese kind of revolution. And they were also having some indirect help from the China, which was proved by the Chinese radio at that time when the uprising took place. China's official radio declared that India is going to become another communist country. So Naxalism in the beginning was not a big problem, but the government's careless approach and lack of directed strategy created a kind of situation that in 2005 it reached to that situation that is was affecting 20 states.
So that's a communist motivated revolutionary groups that have been acting there for decades now?
It began in 1967.
Wow.
And from that time it keep on increasing. Sometime it was suppressed by the government. Later on they tacitly they keep on working. And in the 90s specifically, when central government was not powerful, it was a coalition government from 1990 onwards till 2014. In India it was a coalition government. Whichever party was in power, but it was in power because of around 20 parties. So that leg pulling in the coalition government created a kind of situation that there was no specified strategy to tackle this internal security challenge.
And how is it since 2014?
What?
Since 2014?
Since 2014, it's quite improvement, at least in the security scenario. Now, no major terrorist attack took place in last 4 years, around 5 years.
Is it a different government? It's not a
Yeah,
coalition
it's
government?
a different government and approach of the government. Actually, it's a government of one party. So people can at least blame that those who were from last 15 years challenging that, okay, these government are not working well. Now they have given full power.
Mm-hmm.
And so they have proved, at least at internal security aspect, they have proved that. Because from 2004 to 2014, around 20 terrorist attacks took place in India. And one of the major well-known is 2008 Mumbai attack, where the many foreigners also killed. Around 170 people were killed. The third kind of insurgency is in Jammu and Kashmir and Punjab. In Punjab, it's not that much prevalent nowadays. It's very peaceful, except very minor incidents, which are also not very much prevalent in the public sphere. And in the state of Jammu and Kashmir, only in the Kashmir area, and that area also having very specified places where the militant activities are at very high level. All other area are peaceful, and that activities are close to the border with Pakistan. So there are two kind of insurgency in this area. One is religious extremism, and religious extremism I am using the word because in 1992, where the Kashmiri Pandits who were the aboriginal people of Jammu and Kashmir, they were forced to leave Kashmir because of their religious identity, and the public did not go against the militants, not because of fear but because of support to their religion. And another cause for insurgency in this area is because of Pakistan. The border is very porous and not well specified, so it is not possible to guard every place in the state of Jammu and Kashmir. It's full of hills, forest and rivers, so it is not guarded by the army. So Pakistan is sponsoring terrorism in that area. Now coming to the terrorism. Terrorism have no well decided or defined meaning either at international law or in national sphere. Every country uses the term terrorism to serve its own interest or to shoot to its own needs. But in a general sense, we can say terrorism is a kind of activity which creates sense of fear among the people and specifically in the established government. Now the question arises, why terrorists are attacking the civilians instead of attacking the government system, which was traditionally was the objective of terrorists. The reason behind is nowadays the democratic system is on progress in almost in every part of the world, and every democratic system works only with the help of population. When the people are the deciding factor for the government, and if somebody is attacking the people, the government can be compelled to follow the demands of terrorists or the insurgents. The legal meaning have not been given specific term like a terrorism or terrorist, but under section 15 of Unlawful Activities Act 1967 defines the term Terrorists Act. I have just pinpointed certain words in that definition. Any kind of act with intent to threaten, to strike terror, and there are means which means a person would be using. These are the means: bomb, dynamite or explosive substance, inflammable substance, firearms, other lethal weapons. And why they will use it? To cause or likely to cause. Means there are two things. First is to cause means direct physical response, and likely to cause, it means apprehension of likelihood, means they will cause such and such kind of activity. Or they overcause by means. Certain means have been provided by which they can create the danger to the public functionaries, or to by detaining, kidnapping or abducting they will try to compel the government or any person, either government or any person, to do or abstain from doing certain acts which are covered in this definition. Now I am coming to the federalism and internal security correlation. Constitution of India provided a kind of mechanism where the state government and the central government having their own sphere of legislation. For example, in list 1 of the 7th schedule, there are 97 items on which the exclusive jurisdiction to enact a law is given to the central government. Similarly, in the state list, the items given are completely under the jurisdiction of state legislature. And the third list is concurrent list. Concurrent list provide the kind of subjects or items which are having both the kind of relevance, like local relevance and the national relevance. So here both center and the state government are having capacity to enact any law. The problem arises when a law is enacted by central government comes in conflict with the state law, specifically in the concurrent list. Then Constitution has provided a kind of mechanism under Article 254 that if any conflict arises between law made by Parliament and the state legislature on the entries of concurrent list, then the central law will prevail over the state legislation. Besides this legislative capacity or competency, Constitution also have provided the executive capacity to the state and central government. Usually the law and order problem, policing and investigation having under the are under the control of state government, but these are related to the normal law and order situation. When it comes to extreme law and order situation, as has been mentioned in Article 355, it shall be duty of the Union government to protect every state against the external aggression and internal disturbance. And the terrorism and belligerency are the biggest cause for internal disturbance. And to ensure the government of every state, is carried out in accordance with the provisions of this Constitution. Now comes to the law and order problem. Generally, whenever a law is broken, it's a part of law and order. But when the situation reaches to such a level that a country's integrity, sovereignty and security is at stake, then it becomes not a general law and order issue, but the overall existence of that country. So in order to deal with that situation, the Constitution of India empowered central government to take the things in its hand. But at the same time, central government would be having just assisting capacity, and the state government, as soon as possible, state government would be given the administrative control of the affected area. When the problem challenged in the court, whether a law is enacted by the Parliament is within its jurisdiction or it is a kind of garb used by the central government to legislate on the subject of state list, the Supreme Court gave its observation in the case of Kartar Singh versus State of Punjab, where the court observed that Parliament has the competency to enact a law on terrorism related activities. Entry 1 of the state list provide the provision for public order which is applicable within the boundary of the state. But when the public order is disturbed to the extent that it takes the shape of serious activity and threatening the integrity and national security of the whole country, then the parliament is empowered to restore the peace and security in that area. Similarly, in the Naga people's movement of human rights versus Union of India, the Supreme Court clearly mentioned that entry 2 and entry 2A of list 1, that is entry 2 is armed forces and entry 2A is deployment of armed forces, is within the competency of the federal government. And when the central government is sending army to the state area under Armed Forces Special Powers Act, there are certain situations which need to be taken care of. When area is declared a disturbed area by the President of India, in that situation the state authorities will work in coordination with the armed forces, and the control of that area although would remain in the civil authority of the state, but the army would be exempted from some kind of acts which are beyond the legal capacity of the army. Again, in the People's Union for Civil Liberties versus Union of India, the same issue was raised whether a law is within the capacity of the state or the central government. The Supreme Court held that entry 1 of the state list covers the public order, which already held in the case of Kartar Singh versus State of Punjab. So the court is in these matter also upholding the federal powers, because when it comes to the country's security, the court also take the safe side instead of criticizing the act. After the federal aspect, I would like to bring some light on the various laws in existence in India, which are result of internal security problem. Like I have mentioned in the beginning, that in the early 1950s there was widespread northeast insurgency, and the area was declared as disturbed area. So in order to tackle that situation, Armed Forces Special Powers Act 1958 was enacted. Again in 1960s, the Naxalism got its initiation. Besides it, there were many unlawful activities and groups who are directly challenging the authority of the state and the central government. In order to handle that situation, Unlawful Activities Prevention Act 1967 was enacted. Again in 1970s, internal security was again boiling point, where in the state of Bihar, some group for around 1 month overtaken certain areas. So in order to drag them out, Operation Steeplechase was initiated by the army, and it was successful up to some extent. Again, in 1971, Maintenance of Internal Security Act was enacted, but during the emergency, that was in 1975 to 1977, that act was grossly misused by the government in power, and various political parties, those who were opposing the party in power, were thrown in the jail under this act. So due to huge criticism, that act was later on repealed. In 1980s, the terrorist activities again were on high level, and that is the year in which the Prime Minister of India, Mrs. Indira Gandhi, was assassinated by her guard because of religious affiliation of that guard. Because in 1980s there was insurgency in the state of Punjab, And that insurgency was boiling because the central government began its oppression against the religious extremists. And when they captured a temple, central government sent the army, and because of that act, many Sikh religion followers took the arms in hand, and even in armed forces, they left the army, they left the police forces, and that situation created a kind of internal security in 1980s. In order to tackle that situation, National Security Act 1980 was enacted. Again, Armed Forces Special Powers Act was extended to the Union Territory of Chandigarh and State of Punjab. Another act was enacted, Terrorist and Disruptive Activities Act. This was the first act which was enacted to deal with the terrorist activities, which has used the word terrorist for the first time. In 1990s, the insurgencies and Naxalism again on rise, and Armed Forces Special Powers Act was extended to the state of Jammu and Kashmir. And the year 2000 was again the beginning of millennium with the terrorist attacks. In 2001, the Parliament of India was attacked, and in order to give a response to the terrorist activities, Parliament enacted a law, Prevention of Terrorist Activities Act 2002. And that was very criticized by the civil rights groups and media and other international NGOs. But the one good thing was with that act, there was liability of the police officers. If they are taking any action beyond the limits or objective of that law, there was liability. But another act which is still in existence, that is Makoka in state of Maharashtra, it is not given in there. So under that act, there is no responsibility of the police forces if they are taking action against somebody, even if by mistake. So that act was repealed by the next government in order to just specify some civil rights group, but all the provisions which were criticized incorporated in another act that was in existence, that is Unlawful Activities Prevention Act. After 2008 Mumbai attack, government again enacted a law, that is National Investigation Agency Act, by which a new agency was created in order to tackle the special cases of terrorism and insurgency. In 2010, from 2010 onwards, UAPA, that is Unlawful Activity Prevention Act, was again amended in 2012 in order to incorporate the recommendation of Financial Action Task Force. These are the cases in which the Supreme Court took the note of whether these laws were valid or went against the spirit of Constitution of India. Now coming to there are various groups in India and also all over world. They are alleging that the governments using the special security laws in the situation where it is not required, and under the garb of national security, they are violating civil rights and liberties. So, Constitution of India provided the civil rights and liberty under its fundamental rights, that is given in Part 3, Article 12 to 35. Under these fundamental rights, there is a special article, that is Article 21. It says, no person shall be deprived of his life or personal liberty except according to the procedure established by law. But the problem arises when the civil rights group, they allege that government is violating, or the security forces are violating the civil rights and liberties. But they rarely took the advantage of Article 21, which clearly says that it can be deprived. Life and personal liberty can be deprived, but it will be by following the procedure established by law. And that procedure, as has been mentioned in, as has been held in the Maneka Gandhi case, where the court specifically mentioned that whichever law is providing any procedure for that purpose, that procedure should be fair and reasonable. But the problem arises, the criticizing agencies or the civil society groups, they don't take the remedy given in the constitution, that is Article 32 and 226, where they can challenge any law or any regulation or any action of the government in the court of law, and directly they can go to the Supreme Court. They don't need to go to the lower courts. They usually use the allegation of garb of national emergency is utilized by the governments around the world to silence the civil rights groups. But at the same time, they forget about, although they are, sometimes they have very good reasons to criticize government, and that is the reason that in the next coming laws, the government compelled to take precaution in enacting the new laws. But these civil rights group rarely mention the civil rights of the victims who are affected by the terrorist acts and insurgencies. They mostly support the rights of those who has been arrested by the security forces, or those who are killed in the counterinsurgency operations. Besides this, there is also allegation of hidden agenda of civil rights groups, that they are using the foreign funding in order to stop the government's action against these groups. And a big example can be seen in India's security scenario. When you look at 2005, there were almost 20 states were affected by the Naxalism, and in 2018, this is the area which is left affected by Naxalism. So when the funding and the hidden agenda of some fake civil rights group is controlled, then situation was also in control. In order to give some suggestion, there is a very much need for international effort. There is no accepted international convention on this area which can clearly define what is terrorism, and those who are supporting and sponsoring the terrorist activities in other countries, what should be their liability. There is no legally binding convention on that area. That is required. And at domestic level, in India, the organizational level of the policing and the security forces is still having the colonial mindset that need to be changed. It takes long time to take the action, and sometimes they take the action out of legal bounds. Second area which require the reform is training. Although in armed forces nowadays there is a special module on human right respect, but when it comes to the training of the state police forces or the paramilitary forces, it is still lacking. The third area where I would like to bring some light, that is intelligence gathering, analysis and preventive action. Instead of taking direct action on the violent groups or violent people, the intelligence gathering system should be strengthened so that the preventive action can be taken. They could be stopped before they take the action. Although this becomes sometimes a cause for civil right violation, because the people who were arrested for that purpose, later on many times they found that they were not involved in those activities, only the police forces, in order to get promotion. They picked those persons and created a media hype and got promotion. Later on, after 10 years or 15 years, the situation become clear. By that time, nobody was there to restore their rights or restore, at least to compensate them, those who has been arrested by the police forces. In concluding, what I would say that for the survival of a democracy, civil rights and liberties are undeniable necessity. But neither the democracy nor the civil rights can flourish under the shadow of terror. Thank you.
Yeah, we have about up to 10 minutes. After you have to.
Yeah, I want to give some brief comments and then go to discussions, because I think some of the things that we can discuss here are actually relevant for everyone, even those who don't know the Indian case specifically. And I want to caveat, when you're dealing with what you call someone else's history, it's always, harder. So, you got to take with a grain of salt what I'm saying, because what my knowledge is from research and academic knowledge and less from a lived experience. And I think that does make a difference. However, I think the paper is a good start, but I have some very serious problems with its framework. The first is, if you want to use colonial legacy, you have to decide what you're engaging with. Just saying, oh, there is this colonial legacy and we have it, is not enough. We have to understand what it does. Now, the Armed Forces Special Powers Act was not enacted in 1958. The Armed Forces Special Powers Ordinance was enacted by the British in 1942.
Yes.
In order to prevent, to allow the military to take over any kind of civilian activity, because they feared an invasion from the east. Now, what does that mean? Let's talk about what the Armed Forces Special Powers Act does. And I'll talk about it in the colonial instance, and then how that legacy manifests. And I think, and within this, I'm going to try and frame the other comments. So what does the Armed Forces Special Powers Act do? What it enables is for armed forces to come in and basically take over the operation of civilian and of the management and government of civilian life. So it's basically a form of attenuated military rule. You don't declare martial law. You use the Armed Forces Special Powers Act in order to declare an area as a disturbed area. And then what that allows you is to annul basically any kind of separation of powers that exists, and annul the distinction between civil and military. And it allows the military to function freely. What is the innovation in the Armed Forces Special Powers Act, which was a British innovation and not a local one? And it was the immunity given to military forces against confiscations, unwarranted arrests, death, custodial deaths, seizures. Basically anything that happened, they were immune from. And and the British were fantastic in this. They had these wonderful clauses in which what it actually meant is anything we think is useful, we are going to do.
Yeah.
And also this didn't go undebated. So there was a big fear of retaliation against this heavy-handedness within the British Home Office, the government of India, about the Armed Forces Special Powers Act and how much extent of discretion it gave. So you have this template, and that creates a toolkit, a form of governance of what you do when you have a hostile population. Now, so we're talking British rule here. And what happens to that toolkit?
A hostile population or a certain group which are hostile, because when the whole population is
For the
hostile,
British,
Yeah,
all
for
they had
them.
to say,
Yeah.
and this is why we're talking British, because it helps us.
Yeah.
When we're talking about the British, it helps us understand
Yeah.
how they use the legal and administrative toolkit against the population. And then it's easier for us, despite our possible different political leanings and understandings of what should be done in the present, by looking at the colonial past, we kind of can distance ourselves from what we think needs to be done at this moment and say, if right now we were back in the 40s, be it in Mandate Palestine or in British Raj, what would we think of this toolkit? And then what that helps us do is understand what it actually does, without all this fluff about what should be and what can be and what's whose problem it is. And I think that part of our work as scholars is to do exactly that, is to be able to say, this is what's happening.
Yeah, it's something.
No, you can add after.
Okay,
You can add after. But so part of our work is to do this. Now, how do you do this? First of all, you make sure that you cite all the scholarship that is written about this. In your paper, there is no citation of the massive and incredibly wonderful work that's being done in the last decade about the Armed Forces Special Powers Act. I'm talking about Ujwal Singh's book of 2007. It's absent. New work now, 2017, 2018, Gina Lokanita, Dusinski and Ghost. I mean, you have all these people that are really getting into specific cases, and or even Upendra Bakshi. Already in the 80s, he's explaining to us what the Armed Forces Special Powers Act does. And he says what this does is it creates, I have the quotation here, it creates a parallel system of criminal justice and detention. So you have, on one hand, this state, and this is enabled because of the discrepancy between state and federal laws, right? So what it does is you have the civilian criminal justice system that is at work, and you're using the criminal, the Criminal Justice Act? No, the Penal Code. The Penal Code. Penal Code. You're using the Penal Code, and then alongside it, you have this other system of arrests, other system of interrogation that allows you for more time for interrogation, that allows you to make new and separate detention centers for particular kinds of population. So what you have is two separate systems for different populations that are enabled because of the Armed Forces Special Powers Act. Now, regardless of whatever you say about national security, we have to address the fact that the Armed Forces Special Powers Act was enacted because people were what was it? Let me just see. I want to quote here. They're calling it. Okay. So the reason they're doing it in Nagaland and Manipur is justified because the population poses a constitutional problem. What's going on? They're protesting massively. They're protesting the union. They're at no moment is there an issue with any kind of militancy. At that moment, that what happens is that you have a different order, a historical order than what you're telling, and that historical order has to do first with protest and political opposition that then turns into militancy once that protest is clamped down. Now, and this is another point that I think that we can discuss. So, again, we know that histories are political, and especially histories that justify law. There's always so in the paper you mentioned time after time, in every decade they had to enact some sort of law, which shows that in every decade they had to deal with something. That's tautological. What you need to do is say what wasn't working within these laws, because you have this colonial toolkit and it's changing and it's shifting as it's going along, and there's, for instance, the terrorist terrorist activity
terrorist and disruptive activity.
And disrupting activities, right? So Tada's enacted because of the Kazakhstan insurgency,
Yeah,
right? Because in Punjab there is a secessionist movement that wants to make a state called Kazakhstan, and then Tada comes in to deal specifically with the type of insurgency that was in the Punjab, and then that's one of the things that one of the critiques of the laws are that they're case-based. So there's local conditions, there's a type of insurgency, and then there are certain legal machineries that are put in place, but then they're taken to be used in different states. And that's and that critique, which is not necessarily coming just from one side politically, it's coming also from the security forces that say, this is not helpful to us, we have a totally different situation here, or the civil rights group that say, how could this heavy-handedness is not going to work, when we have a totally different regime. Insurgency happening, so a different political context for the insurgency. And so I think that what would make better sense is to actually highlight what are the changes that are causing these new legislations, both in the political context, but also the actual machineries in place. What's not working? What's not working? Why is detention shortened? Is it only shortened for civil rights reasons, or because of contestation? Or is it the security forces that are saying we don't need these long detentions anymore? We actually need to target specific people. We don't want these hundreds of people being thrown for long periods of time because it's useless. And so what I'm saying is, again, these histories, you can continue to hold a political view of what is the reason or what the balance should be, and still this history has to be part of the context, because otherwise it doesn't hold water. Okay. And so the next big issue, I think, is, so again, Article 254. Super serious, big controversy, serious debates that lead to this compromise between the balance of power between central and federal legislation. You either have to highlight it or take it out of the paper. Because just saying that there is this balance of power and there is this decision is not enough to explain what exists today. Because that controversy continues to live. It's embedded in the debate itself. The discussion is not forgotten. And I think that's a very important issue. And even, using the articles as the Constitution just as face value, without explaining the different debates around them, I think that also doesn't work unless you're citing other works that deal with it. No, obviously you can't go into everything, but then what you do is you cite, and there's new fantastic books out.
That would go beyond the limits. I could write down on everything, but limit is 12,000 words.
No, fine. No problem
and
with the
I
limit.
want to show the legal architecture. If I'm not touching upon those areas, okay, this is also there.
No, but listen. So say you want to talk about certain articles. So there's Rohit Dey's new book. It's now a bestseller in nonfiction in Delhi. So he writes all about these articles, and he writes about these debates. All you have to do is Rohit Dey, 2000. I don't know if it's 2018 or 2019. I think it's 2019. You write that, and then you're referring to this context, because otherwise, you don't have. It's not telling us enough. Okay, now, last. I think the idea of how emergencies are defined in India are very, very important.
Yes.
Now, emergencies are never only about security, like I like to say, because I don't know how to say it otherwise. They're also about industrial relations. They're also about financial crises that have to do with labor disputes. This also has a history, and also threats to constitutional machinery. Now, this is different than militancy. And so when you're framing it as in militants hiding in people in civilian homes, that's just framing it in one way, and you have to widen that scope. Now, you could also say, I'm not talking about all the rest of that, because I don't have time, because I want to deal only with the issues of militancy.
Limiting the scope.
So you limit the scope and you say, I want to talk about militant armed forces of in such and such areas, and then you can talk about the different movements. But that's another thing. So Naxalites and like it's not enough Naxalberry,
Yep.
and it doesn't tell the story. And so for me, I what I would like to talk about is when you're writing your choice. So where you are. What your relationship is to the state narrative. And this is a very big issue for all of us.
Yes.
It's a big issue for all of us, whether we're opposed to contemporary government or we're not, whether we support these actions, but there has to be a distance
Yes.
between academic scholarship
And ideology.
and state narrative.
Yes.
And when that becomes too close, and you can just look at it and say, okay, where am I coming too close? Where, in Hebrew we have a good word for it. It's called hasbara. Hasbara.
Which means?
Hasbara means explanation. The act of hasbara. It's not the act.
Explanation and advocacy.
It's explanation and advocacy, and it is definitely considered in the contemporary Israeli government. It's considered part of Israel's war on terror. So literally, hasbara is part of this. Now, when we're writing, and it doesn't matter if we're writing histories, because hasbara, it's not an invention of the last 5 years. Most governments did it; they just didn't say that they were doing it. Now it's become, part of an agenda, and it has a what?
You have a
Sometimes they say it and they don't do it.
Maybe.
That's the problem.
I don't know. Whatever it is, it doesn't matter. This is a very controversial issue, but I think the what's important is
the dodgy name that does this.
the Department there's the Office of Strategic Affairs, and that has a department of.
It's really dodgy.
Yes, it is dodgy, but whatever. That's the point. They do their job, we do ours, and it is not the same job.
Yes.
This is very important. And so as scholars, and this is regardless of your political opinion, regardless if you're, because one of the things that was interesting to me was two things, and I want to explain them. So you mentioned, the only figure you mentioned as the forefathers of Indian independence is Patel, is Sardar Patel. And at some point, you mention Ambedkar, but you don't mention Nehru or Gandhi. And then what you see, so immediately I'm like, okay, gotcha. I know what page you're on. Fine, I'm gonna revert to, okay, this is gonna be scholarship that has a different political opinion. Whoever, there's this fantastic book called the Patel-Nehru debates. It's a small book, fantastic if you want to understand, like at the beginning of India, these really debates about civil rights versus security and development and all these issues. So it's right there. So you say, okay, I'm a Patelist in that sense, fine. But if you're doing that, you have to acknowledge the other options that existed, or what the fight was against. And it's the second thing that you do is you say the Indian Constitution had, you're basically saying Indian Constitution had too much civil rights because they were still thinking, I'm doing a little bit of shenanigan here, but you're basically saying that they were so anti-colonial that they harnessed the Constitution to give too much civil rights and less attention to national security needs. And I beg to differ, and the reason that I beg to differ here is that even pre-state, you have these fights that that Congress, who then goes and becomes the ruling party, are saying in their election pamphlets, the first thing we're going to do is do away with these emergency laws and sedition trials. Yeah. And then in 1937, when they take on positions in the provincial governments, they enact the
Their
exact
own-
same public safety acts, and everybody's like, what? This is pre-independence.
May I add something?
Yes.
Whatever a government or the authority in power enacting laws, their laws will remain same, but the objective will change. Colonial object and interest was different than the India's interest and objective. When although security problem was there also, security problem here also.
So-
But the interest, what the interest they want to serve. Earlier they want to just extract as much resources from India they can. They did that thing. That's why they didn't called even India as a colony. All over the world, Britishers use the word colony, but never they give India as a colony because it would have affected the colonial interest because other colonial power could have fight for that colony, and that is a prized colony for India or for British. So. and-
Yes, but it doesn't mean the fact. So what you take from colonial legacy is a political choice.
when
It's
what-
not exactly like you're saying, there is this law and it's going to continue and that continuity has to happen. It's definitely something that is a political choice. I choose which laws I'm going to accept and which not. Yeah.
Do I need to? Although this C has mentioned very good points, but may I clarify on something, or I just need
Let
to
me
take
just make
input?
one, two factual errors that you have made. One was that you talked about that there has not been a single terrorist attack since 2014, which is factually wrong. We have had very recently
we- when-
Pathankot
yeah, you can
attack we
say
have
but
had and other attacks which you conspicuously did not mention. So I don't
not
know.
conspicuously, but it may not have come in my mind. But there's nothing as such
And
that
one
I'm
point that you
just
missed was
strengthening and
national emergency, which is also part of the constitution, which is given in the article
yeah.
352. I think when you were mentioning about the constitutional thing, you did not include national emergency, which specifically says the president of India, if he feels that the country as a whole or part thereof is threatened by any
352,
armed rebellion or
356
external
and
aggression, they can.
360.
So that also you missed. And talking about Naxal issues, you have sort of clearly demarcated between 2014 and after and before.
Just for
I think
example,
that's too much of exaggeration because
that's what
no
a certain
such big issue cannot be resolved in a matter of
you are
3-4
right,
years.
you
No,
are
but
right.
maybe you can explain why he's putting the
Actually,
cutoff
my
date at 2014.
certain-
Not everybody knows.
No,
certain
sort of
reference
things I felt, sort
goes
of,
wrong
Wait,
and
wait. Oh.
there were certain references which I haven't mentioned because of ideological bent or anything else. Like you said, I use the name of Patel. When a person took the efforts to integrate India at the time of when India got independence in 1947, India was having two kind of system. One is British India. Second was 562 princely states. 562 princely states in India. And the Britishers gave the option whether they can become part of India or Pakistan, or they can declare themselves as a nation. They can stay like that. It wasn't expected from the 200 years rule, that they will leave India in that way. Britishers left India not because of their choice. They were devastated in Europe. They were not having the capacity. If there is any revolution is going to take place in 1946-7, they would not have returned from India. That was the situation of that time. And when it comes to the Afsafa affected areas, I met the people from Nagaland, from Manipur. They have studied with me. They told me they have two choices. Whether they can be part of government system. If they are not, they will be compelled to become part of insurgents. When the population is living under the fear, and if state authority is not taking its due role, then the insurgents would declare that we are the population who are opposing, not we are the group. That is happening in Naxal areas also. Naxalism was.
But it's different for different times and different areas, and I think this is part of it. So if you do an ethnography and you go up to Manipur and Nagaland, and then you can say, this is the category. People have two choices, but it's not the case. on the ground. It might be the case in 2012. It might be shift in 2013. Right now, there's shifts. You can't even. So this kind of very categorical divide. It might be good for as a government explanation for why they're doing things, but it's not from a scholarly point of view. Now maybe
No,
I'm not just
No,
I'm a sociologist.
Yeah.
And so for me, I think as a law, from a law and society framework. So for me, when you say people have choices either to join an insurgency or the government forces, it's obviously not based. It's not a research-based category.
Okay.
And so, and if you want to put that in, it should be.
Rajesh, do you want to
Yeah,
see if there are more questions?
Yeah.
Comments?
Please.
So actually I had
Yes, thank you very, very much. I had one question which goes to the interplay between the regulatory framework and in particular with IHL, and I was wondering whether any of these unrests had ever been looked at as a form of armed conflict with the consequence that the legal regime changes.
It's sort of armed conflict in the northeast region.
And
I can
that's
say.
how it's being considered
Yes,
by the
yeah.
government.
Yeah.
It said
It's
that's
a-
an armed
yeah.
conflict.
Sometimes yes and sometimes no.
Yeah.
So sometimes it's considered, and
You're right.
sometimes the Gorkha movement.
Yes.
So Darjeeling, it was definitely considered like an IHL.
And when was that? My ignorance?
Gorkha is
When was?
when's the
It's
what's
many a time they have taken straight on
it's ongoing, but when
Yeah.
does it begin?
When it comes to Kashmir, any sort of insurgency has a tendency to be declared as a terrorist activity because of the presence of Pakistan and the involvement of apparent
Yeah,
involvement
you're
of
right.
Pakistan in those affairs. But when it comes to the northeastern part of India, there are the 7 states. In those states, when these things are taking place, it's more of called armed conflicts and all that. Between, I mean, it's more of yeah.
I would have assumed
Yeah.
the opposite.
Okay.
Yes.
One thing that goes beyond your article, which came to my mind when you were speaking here, it's very interesting to look into how British mandate laws developed in countries, even for your experience, just to understand better when you look at an Israeli situation or other places, it's very interesting to see how things went one way in India and sometimes the other in Israel, and how much time it took. Okay, we are now still looking at British mandate laws in Israel. Okay, so it's interest recently, even as it goes to terrorist acts. So. And you can draw conclusions for that from this comparative work as to your work, possibly.
I actually have an article coming out on the anti-terrorism laws in Israel and India and the different trajectories.
In English.
Yeah, hopefully in Securing Dialogue, you got to cross your fingers after the revision. But yeah, it's just about that. Yeah,
Is it specifically
I can't
focused on?
it's actually saying that in India, India did. It took in the colonial toolkit by actually legislating it very early on. 1950 is the Preventative Detention Act. So it takes on the responsibility of it. While in Israel, what was used was the emergency defense regulations that were never really incorporated into kind of Knesset law. And no, they were in effect for sure, but never incorporated. And there's a huge debate in the Knesset that goes on in 51 and then in 62, and it's actually Begin, who is the opposition leader, that says, if you're not willing to legislate this, why are we using it? and it's a kind of interesting change where the right wing is actually attacking the so-called left wing for using these military
And they're
laws.
intentionally keeping them at arm's length?
They did
just the
until
way-
2016.
Yeah.
2016
Yeah.
that
Right.
changed.
But
It has constitutional effects
Yeah.
also, because we have basic laws, not a constitution here, and it's left. Everything after the laws has to be under the constitutional proportionality, for example, clause, while you can still use British mandate laws for a long time.
Without-
You
There's,
could.
there's actually a fantastic book by someone here, Yoav Mechuzai, who writes about the fluidity of emergency jurisprudence
In
in
English.
Israel. Fantastic, by
English.
SUNY Press.
Even
So
though about what you said, what you said, the armed acts, and what you said, the reliance on mandatory law, and that's a paper that I'm writing currently.
All the papers on the table now.
Like
In English?
very early on, no, in Hebrew, because I want. My clientele is the current Israeli Supreme Court. Very early on, there's a ruling of the Israeli Supreme Court saying that all mandatory legislation is subject to the mandate declaration of the League of Nations,
Yeah.
which assures human rights.
Uh-huh.
And they assure that they will. So there's judicial review, constitutional judicial review for all British
interpretation of this
legislation,
law.
and they promise, the Israeli Supreme Court actually promises that they'll review separately every emergency regulation, but they never do it.
When did
When
they
is
promise
this?
that?
That is a Karbuti. That is 7 Bagatz High Court judgment,
which year?
7-48. And
So it's the seventh case
Everybody
in the
forgot that.
state.
and that's
Wow.
that case law is still formally
Amazing.
obligatory today, but they haven't done it.
Right.
So can you judicially review, can you bring an administrative review challenge to the Supreme Court saying
Oh,
you haven't done
Yes,
it?
Yeah, I mean, we
yes,
have
of
ho-
course.
yeah.
That's
Including
exactly
some of our
that-
careers what
that's
we're trying to
exactly
do.
what my
You're
paper
right.
is
Right.
that I'm writing is trying to argue.
Yeah.
Wow.
One
Suggest
more
countries
clarity
that
I
has
need from
judicial
you.
review.
You
I live in Italy.
on
Maybe they have problems.
Yes.
That's,
No, I just wanted to make sure
Okay,
that
okay.
there wasn't any.
yeah, question. You said that instead of enacting special tools, why don't we go by the regular laws? You said in my article, you were mentioning it.
Yes.
Yeah, every time they are coming with special tool or special enactment. And when the situation is not regular, then how can we expect that law will be regular?
So with this, I think that there was this incredible debate for a decade where people overly discussed this issue. I think of emergency and exception.
Yeah.
Carl Schmitt intersection with everybody else, with Agamben, Nomi Lazar, Michael Ignatieff. You have all of this debate about what is exception, what is the regular, what is irregular, and I think engaging with that is necessary because we know that there's two possibilities. One is the decisionist state that says there is normalcy, and then there's the sovereign can declare the state of exception, which is kind of Schmitt, basic Schmittian stuff. And then you have all the others that are saying, exception is never a moment, it's always a process, and it always exists alongside the normalcy, right? And so especially in places where you have protracted conflict, be it international conflict or internal conflict, saying that the situation is irregular it's token. It doesn't help us understand the legal situation. It doesn't help us understand. It doesn't help the bureaucrats understand when they can enact certain things and when they can't. So if there's a disturbed area, is it a disturbed area for 1 year? Is it a disturbed area for 30 years?
Yeah, there must be review for that thing.
Can it be a disturbed area for 30 days? Like, what is this thing about what is disturbed and how do you map this? How do you make these choices?
But that
And so that's the thing, right? So then you have to, so in the irregular moment, we have to trust our bureaucrats. We have to trust the bureaucrats. We have to trust them that they will declare emergency and disturbed area only when they must. But if the situation is consistently irregular and you constantly have an emergency, how can they make that decision?
But one instance I wanted to mention, like in state of Arunachal Pradesh.
What?
State of Arunachal Pradesh.
Yes.
Yeah. Certain area were disturbed area earlier.
Yes.
Now they are not.
I know. No, no.
So,
No, if you ask me, like, if you ask, are we finishing?
Nice. We will talk later on.
Sure.
Yeah.
Okay.
Yeah, right.
So, thank you, Rajesh. And before we conclude that, I just want to.
Yes.
I'm going to separate you.
Then
Never.
we're whispering us.
But can't you just tell us what you're
I've
whispering
asked
about?
I was asking him since
Man.
when Israel's been in a state of emergency.
Since
And
1948?
my answer was that the land of Israel has been for most years in a state of emergency since 1914, and I think that in a constant state of emergency we are since 1931, or at the latest
36. 36.
No, but the 36 emergency ordinance is a correction of the 31.
No, it's true,
ordinance.
but because it wasn't really published, so the question is, can emergency be an emergency if it's not published? So we can. I think Charlie's
So
goal
this is why I
on
said I
36.
said one of the
Undeclared. Kind of.
So,
Yes.
just before we break down for lunch, just want to emphasize that within all the concept of everything, I think we've basically limited your article to 2/3 of what you actually want to write, because we
Yeah,
the
yeah.
word space
Yeah.
and everything, and clearly there is much more development to take place, and I think that discussion, take into account that everything is going to take your article in a very, very good place at the end of the process.
Yes.
So thank you, Rajesh. Thank you, Yael.